financial accounts. Let's talk about what happens to these accounts while you are alive and well, if you are alive but incapacitated, and what happens to them, who has access, who collects them when you die. So let's start with now. You're well. If you want to access your financial accounts, if you want to check on your stock, if you want to buy more or sell some, you can do that, right? You call your financial advisor, or if you don't have one, you call the company directly who's managing these financial accounts, and you tell them and you do whatever you want to do with them. What happens if you become incapacitated or when you die? Let's say you are in a car accident and you are now incapacitated. You are in the hospital in bad shape and you may be there for several months, let's say. Well, someone has to step in your shoes and pay your bills, pay your mortgage, make medical decisions, and so on. But in regard to your financial accounts, let's talk about what options they are. First, you may have a general durable power of attorney in place, a document that says, if I become incapacitated, right, this situation, I appoint this person to do a lot of things. Among those things is to access my financial accounts, maybe sell some stock and pay for my care, maybe sell some other type of investment account and pay my mortgage, or whatever the situation may be. So you may have a power of attorney in place that appoints someone, so that should be easy. That's probably the easiest one. Second, if you don't have a power of attorney in place, a guardianship may have to be filed. So someone will have to go in front of a judge and say, hey judge, he or she were in a car accident, here's the medical records, appoint me as their guardian so I can start making decisions for them, pay their bills, access their accounts. That's not fun. That's not fun. That's expensive. It takes time. You have no control over who applies and so on. So let's not get there, but that's how it works when people don't have a power of attorney in place. Three, there is a limited power of attorney. Most companies, I want to say most bigger financial investment companies have their own limited power of attorney, if you will. So be sure to ask, if you don't have a financial advisor, ask the company directly, is there any way where I can designate someone to have access if I've become incapacitated? Not as a joint tenant, not as a beneficiary, just to allow them to have access to these accounts, to this money, if you need to get in, if that situation arises. Of course, make sure you put someone you trust. You don't want to have someone there who may misuse that money and you come out of your incapacity and you realize that they did some really bad things with your money. Fourth, if the accounts can be owned by a trust. So if the account is owned in the name of the trust, your trustee, your successor trustee, will likely have the authority to access these bank accounts and do whatever needs to be done at that time. So that's incapacity. One of the four things. Ideally, again, you have a power of attorney in place because it's good for so many other things, or you have the account owned by the trust if you have one, or at least contact the company and have something on file with them, and that would be good only for that company, but at least it's something. Also, it's worth mentioning, be sure that people know where these accounts are and that you have them, because if you become incapacitated, how are they to find them? So have a safe plan in place for that. Now let's talk about death. What happens to financial accounts when a person dies? Well, it depends. If you have beneficiaries listed, those beneficiaries will access those bank accounts, right? So either the company has the beneficiaries' phone numbers and addresses, and they may try to contact if they don't hear from anyone. That's once they are certain that you passed. Or it is up to the beneficiaries to contact the company and say, hey, so-and-so passed, I am listed as a beneficiary, here is their death certificate, send us the check. And that's kind of roughly how it goes. If you don't have beneficiaries appointed, or if the beneficiaries who you have listed predeceased you or died at the same time with you, that's when it will likely have to be probated if it's over $50,000 in Oklahoma, meaning that your loved ones, your family will have to open a probate case with the courts in the county where you resided and try and collect that money that way, and then distribute it according to whatever the situation may be, the law, or if you have a will. So we don't want to get there. Probate is expensive, it's public, it deals with a lot of other things. Ideally, you have beneficiaries listed. And third, again, we're going to go back to the trustee. If you have, for example, minor children and you don't want to list your minor children as beneficiaries just yet until they become responsible adults, you can have a revocable trust if you have a trust listed as beneficiary, and then the trustee of that trust will be able to collect those accounts. I hope this video helped. Be sure to subscribe to our YouTube channel. There is a button or a link there below. And email me if you have topics for future videos. Thank you for watching.